The first case to come before the court is State versus Chandler. We don't have anybody on the other side, so you have 15 minutes.
Thank you, Your Honor. May it please the court, my name is Natasha Ferrer, and I represent the appellant of the state of Ohio in this matter. This case involves this specific issue, an assignment of error that the state has alleged here involves the trial court's interpretation of the intervention statute, specifically 2951.041B1. And intervention in lieu has this, the statute contains several requirements that an offender must meet prior to participation in the program. And if the offender does not meet those specific requirements, this trial court errs in granting that particular offender participation in the program. One of those requirements is under B1, which requires that an offender not have any prior felony convictions or have participated in an intervention program or a similar program. However, one exception contained within that subsection is that if an offender has a felony that was not an offense of violence conviction in their record, and that the state actually recommends that that particular offender be eligible for participation in intervention in lieu. In this particular case, it is undisputed that at the time of Ms. Chandler's plea and motion for intervention hearing, that she in fact had a felony conviction for drugs in Medina County and was on community control. And because of that prior conviction, the state did in fact object to her motion for intervention in lieu of conviction. The trial court recognized that she did have that conviction, however determined that Ms. Chandler was still eligible for the program because the trial court's interpretation of B1 in that the trial court believed that Chandler would have had to have actually been convicted prior to the charges being brought in this matter.
And where do we find that? Is that I don't recall seeing that as a part of the trial court's order. Was that the discussion that was on the record?
It was on the record, correct, Your Honor, and it was actually pages 7 and 8 of the transcript is kind of where the trial court went through and put that reasoning on the record.
But she had been indicted at the time that she moved for treatment in lieu, correct?
She had been indicted at that time, and it's unclear whether or not she actually, at that point, actually entered a plea in the Medina County case and not had yet been sentenced. But definitely at the time of the plea hearing in this matter, she had been convicted and was on community control for that charge. In this case, it was the trial court's interpretation of intervention in lieu that allowed her entrance into the program. And when reviewing interpretation of the statute, the trial court must review the plain language of the statute in order to determine legislative intent. And only if that legislative language is within the statute, if it's ambiguous, would the trial court look to outside the legislative history or actually reviewing the consequences of the literal interpretation of the statute. And several other districts, the 2nd, the 10th, and the 12th, have all interpreted that 2951.041B1 is clear and unambiguous and therefore does not require any sort of interpretation. Therefore, and the trial court actually in this matter on the record during the hearing stated that a literal interpretation of the statute would in fact preclude Ms. Chandler from participating in intervention in lieu. And the state would suggest that at that point it was that Ms. Chandler was in fact not eligible and the hearing should have been, her motion should have been denied at that point and no further interpretation of the statute was necessary.
And we have the transcript in front of us.
Correct, Your Honor. Yes, it is contained within the record. Therefore, because of the fact that Ms. Chandler had been convicted prior to her entrance into the program and because of the state's objection to her admittance into intervention in lieu, Ms. Chandler was not eligible for the program and the state would state that the trial court erred in granting her entrance into the program and therefore would request that this honorable court reverse the decision of the trial court and remand the matter for further proceedings.
Let me answer your question, if you don't care. The conviction in Medina, was that her first conviction?
I cannot tell you 100% certain that it was. I know that that's the only conviction that was brought into the actual hearing itself, so I'm not aware if she had any other convictions. I'm assuming she probably didn't have any prior felonies, or else the state probably would have addressed that and raised that at that point.
Okay, and you said she was on community control in Medina. That wasn't, that was just a straight conviction. It wasn't treatment in lieu in Medina.
No, it does not appear so.
Okay, I'm just wondering why, if that was maybe her first offense, why that wasn't a treatment in lieu too.
And that is an interesting point, Your Honor, as well, that maybe that would have been something that could have been pursued at that point. I'm not 100% sure of the circumstances surrounding that, but just reading from the record, she was on community control for that other offense.
I'm a little confused at the order of these offenses. So is it your understanding that she was charged with the Medina offense prior to this one, the one that's on appeal?
The record is not entirely clear as to which was charged first, or if they were charged in this same area of time. All that it is clear that I can tell from the record is that she pled and was convicted in that Medina case prior to going forward and pleading, and the trial court actually granting her participation in intervention and was here.
When you say that she pled and was convicted on the offense in the Medina case, I thought I understood you to say that she was awaiting sentencing.
It appears that at one point she may have been awaiting sentencing and at a prior hearing, and then at the time of the actual plea hearing here, which appears to have been a little bit later, that she actually had been sentenced in the Medina County case. So I believe that there were maybe a couple of pre-trials or a pre-trial prior to the actual plea in this manner.
And I raise that because I just want to be clear, on the procedure as to whether or not whatever happened in Medina constituted a conviction. We've said in other contexts that there needs to be a plea, the finding of guilt, and sentencing.
Correct.
And so that's what was a little fuzzy to me.
And I would also point out to the actual language of B1, and it does state pleaded guilty to or convicted of.
Okay.
So we're actually covered under both of those circumstances because it has that language contained within the statute. It doesn't require a conviction per se, but an actual plea of guilty to those prior charges. So under either scenario, Ms. Chandler would not have been eligible for intervention in lieu of conviction, and therefore the trial court did in fact err in granting her participation in that program.
And it is in the record as to, I'm sorry, I'm getting a little confused too.
No, I'm sorry.
It is in there, it's not you, it's just not knowing exactly everything. It is in the record as to when she entered her guilty plea.
In the Medina County case?
No, in Medina County.
In Medina County case, there was only discussion of
that she had
already entered the plea and was convicted.
Okay.
Contained on the record both by the state as well as by the trial judge. There are no further questions, Your Honor?
I don't believe so.
Thank you very much.
Thank you. The court will take the matter under advisement and issue a written opinion that will be sent to both sides. Thank you.
Thank you.